Thank you all for joining us today. It's our first webinar of 2026, and it's a collection of changes, upcoming regulations that we think the travel industry need to know about. We've got 4 different topics today. Reese is going to talk us through a recent change on the Digital Services Act. And a recent case that came in there. James is going to talk about the Online Safety Act and again how that is catching some travel businesses unexpectedly in some cases. I'll give you an update on the EU Package Travel Directive, what's happened and what is happening, and then Jess will finish us off with a recent ATOL change. So without further ado, I will hand over to Reese.
Thanks, Lucy. Good afternoon, everyone. My session is about the Digital Services Act, and I'm just going to give a little overview about what the DSA is, in case anyone on this webinar doesn't know that already, how it applies to travel platforms, and then I'll go and talk about a recent case which I think can be quite significant for the travel sector, and that's the Zalando case, where judgment was handed down late last year. The DSA is a European regulation, so it applies to anyone making available their services to consumers in the EU. So if you're only UK facing, you don't need to worry about this, but if you are facing or have consumers in the European Union, and I should say actually whether those users are consumers or business users, this regulation will apply because it applies to B2C and B2B businesses facing the European Union. So the main purpose of the Digital Services Act, people will call it a landmark regulation, and it applies to online businesses, and its main purpose is really to try to make the internet safer, and it's particularly targeting what's known as illegal content, so content which is placed on the internet which is illegal. It's focused on illegal content, trying to address that, trying to minimize the distribution of that sort of content, and to make those companies which are in some way involved in the storage or the distribution of that material accountable for it in some way. So illegal content in a travel context could mean something like a package holiday, which is advertised without any kind of financial protection, which is a criminal offence, or alternatively, a hotel which is being marketed in breach of consumer protection law, something like that. In the travel sector, I mean, it could be broader than that. We obviously have sort of certain fraudulent issues in the travel sector as well. But when it comes to the DSA, that's the kind of thing we're talking about when it comes to illegal content. So the DSA, as I have already mentioned, will apply to a bunch of different actors in the online industry. And the one that we're going to be focusing on today is the part which relates to online platforms, because this is likely to be the one which is most relevant to what I will call travel platforms during this session. And by travel platforms, I mean online travel agents or booking platforms, basically. So online platforms, as defined by the DSA, will capture any company which stores information which has been provided to them by a third party, and then makes that information available to other users of the platform. So you can see that there is sort of an obvious application here to online travel, because a lot of online travel platforms will take product information from third parties. They could be accommodation providers, transport providers, whatever, will store that information on their servers and will then make that information available to users of the platform, whether that's consumers or business users of the platform. So on the face of it, it does appear that, it is of application to travel platforms. And just to give you a very high level kind of overview of what some of the key obligations are for online platforms, if they are called by the DSA, well, um, they have to have what's known as notice and action procedures. So these are mechanisms which will allow users of the platform to file notifications that there is illegal content, in their opinion, on the platform, so that the platform owner or the platform operator can be made aware of that illegal content and then decide what they want to do, whether they agree uh, that it's illegal, in which case it's taken down, or whether they disagree and the content can remain on the platform. So that's one of the mechanisms by which illegal travel listings um, may be addressed through this new regulation. There's also then obligations to publish reports about content moderation. That's basically publishing information about what content moderation activities the travel platform's been involved in. The platform has to have a complaints handling system if anyone's kind of unhappy with the way that the platform has been dealing with content takedown issues, for instance. And then there's obligations to publish information on the platform. Some of that information will be about the platform itself. You may or may not have seen some travel companies already publishing the number of monthly users that they have on the platform. So there's an obligation to publish that sort of information. There's also an obligation to obtain specific sort of information about the traders who are using your platform, and then um, publishing some of that information to users of the platform. And that's so that customers who are buying travel services on the platform, know the identity, contact details, things like that of the company that they're actually dealing with through the platform. Um, there's then some rules around online advertising, giving information to the customer about how recommender systems operate. So if you present search results to a customer in a particular way, you have to give information to the customer about how that's done. There's some prohibitions on dark patterns, quite similar to the UK DMCC. So these are features of platforms which may kind of unfairly manipulate users or mislead users on the platform. So there's prohibitions against that kind of thing. And then the last thing I'll mention is just an obligation to appoint an EU representative if you're based outside of the EU, so that there is someone within the EU that the authorities can send notices to and things like that. Up until now, there have been, I'd say, different approaches within the travel sector, with some travel platforms taking a position that they're within scope and some travel platforms taking a position that they're outside of scope. And as I see it, the way this has played out is that, those who are within scope will think that, well, they're in scope because they um, receive and store descriptions of travel products or images of travel products which are provided by third-party travel suppliers, and then they make that content available to users of their platform. So that ticks the boxes of the definition of an online platform, therefore they're within scope. Um, However, it's not always been that clear, because there are arguments that certain travel platforms are not within scope. And these arguments tend to relate to issues such as the fact that the travel platform doesn't simply receive and store information on its platform. It actually manipulates that information in some way. So it may standardize the content it receives from suppliers. It may edit or rewrite descriptions that it receives from suppliers. It may curate its own images. It may play about with the formatting. And sometimes it'll sort of combine its own content with content which comes from third-party travel suppliers. So for those reasons, some travel platforms have taken the view that they are outside of scope because they do more than what that definition of an online platform is, which is somebody that stores and disseminates information. However, that analysis has now been sort of cast into doubt, really, by this judgment which came out of the European General Court last year concerning the company Zalando. Now, Zalando is kind of online platform which markets for sale fashion and beauty products, and it has sort of two aspects to it. There's a retail store where it makes available effectively kind of its own products, and then there's a marketplace element to the platform where third parties are able to market their products for sale through the Zalando platform. And basically, a dispute had arisen between Zalando and the European Commission because the European Commission had decided that Zalando was a very large online platform, which meant that it had certain kind of enhanced obligations as an online platform. Zalando challenged that on the basis that its marketplace isn't a platform because Zalando actually exercises significant editorial and curatorial control over the content that it receives from third parties. So it said that, we verify the information that we get, we edit it, we supplement it. So we're not just taking information from these third-party suppliers and putting it on our platform. We're actually doing something to it before users of the platform can see it. So on that basis, Zalando was arguing, well, we're not an online platform because we do more than, those two limbs that I mentioned on the previous slide. We're actually sort of controlling the information ourselves. So that argument is, very similar and resonates with the position that some travel platforms have taken in relation to the application of the DSA, because they verify, edit, supplement the information provided by third parties. But actually, the General Court of the European Union disagreed with Zalando and thought that even though it was exercising that sort of editorial control over the content it was receiving, that doesn't take it outside of the definition of an online platform. And my reading of the judgment is that the court is basically saying that if in substance you are still disseminating information on your platform which is received from third parties, then you are still caught by the Digital Services Act, even if you are perhaps changing some of the text or the formatting that you're receiving from that third party. I think the point is that the substance of the information is still information which is coming from a third party and which you're then displaying on your website. So on that basis, you are an online platform. Therefore, you need to comply with the DSA. That's quite a significant decision because it potentially it's going to bring in many more companies than what had been the case. But I should say that Zalando is appealing the judgment, as I understand it, and that's going to take some time to work through the courts. But as things stand at the moment, the Zalando judgment stands as I've described it until it's overturned, if at all, by the appeal court. In terms of what does this mean for travel platforms? Well, it seems to me that the Zalando judgment, significantly narrows the possibility of arguing that the platform is out of scope because, these arguments that travel platforms may have been relying upon previously, that they were curating the content or editing the content that they were receiving from third-party suppliers, is not going to be enough on its own to put the travel platform outside of the DSA. The General Court had made it really clear that what matters is whether the travel platform is storing information provided by third parties and then making that available to users of the platform. And it doesn't really matter, or it doesn't make a difference to the analysis that there is this editorial control, or whether the travel platform standardizes presentations, or whether it sort of supplements that information with some of its own information, provided that actually substantively the information is what was originally provided by the third-party suppliers. I just had a couple of thoughts here at the end of this slide. I mean, Zalando doesn't deal with everything, and it does seem to me that there may still be some opportunity to create a distinction between kind of the Zalando decision and a travel platform, particularly around things like the extent of editing. I mean, if what's published by the travel platform on its website is you know, completely different from, the extent of editing means that it's substantially different to what was received from the third party supplier, then that may be enough to put the travel platform outside of scope. I also wonder whether there may be a case to distinguish Zalando on the basis of travel platforms which may kind of dynamically pull content from third parties before then presenting that to the user of the platform on the website, which may be sort of slightly different to the DSA concept of storing and dissemination if it's done in this way, which dynamically pulls information from third parties. So I'll just mention briefly next steps on, and this is the last slide because I'm running out of time. But in terms of what travel companies should do now, well, what I would suggest is if you've previously taken the decision that the DSA doesn't apply to you, then you may wish to revisit that assessment in the light of the Zalando judgment and the apparent kind of narrowing of the possibility of arguing that you're out of scope. And then if you are in scope, then there needs to be certain steps carried out to comply with the DSA. And I just sort of repeat here some of the ones that I had on one of the previous slides about what travel companies need to do. So it's just putting in place, content reporting mechanisms, complaints handling mechanisms, publishing information about the number of monthly users, the traders on your websites, and that sort of thing. So I'm going to leave it there for now because I have probably overrun, and I will hand back to James, who I think is doing the next session.
Hi everyone, thanks Reese. So yes, I'll be discussing the Online Safety Act today and how it could apply to travel companies. So to go through backgrounds, the Online Safety Act 2023 is the UK's framework for regulating certain online services. Similar to the DSA discussed by Reese, it focused primarily on illegal content such as fraud, scams, and other criminal content. It is a broad UK regime, and despite the news focusing on social media and adult content websites, it does apply quite broadly. And Ofcom, the regulatory body for the OSA, does not ask what sector you're in when determining whether the OSA applies. So it's not, are you a travel company? Are you a social media company? Rather, it's driven by the functionality of the platform itself. So it asks whether the platform enables the users to do certain things. Two of those things, the main two, being the search services and user-to-user services. Search services being allowing users to search across content, and user-to-user being services that allow one user to encounter another user's content. We'll look at each of these in turn and highlight how travel businesses may fall within scope. So in terms of the search functionality, it is defined broadly as a service that is or includes a search engine. But I think something that's important to state with the search services is that Ofcom within search services has specified vertical search services, which it defines as services that enable users to search for specific topics or products or services offered by third-party operators. And then key for the travel industry, it picked out flights as an example, which is just a clear indication that they are thinking about travel companies when they're talking about the OSA. In terms of why search services are particularly relevant in travel, travel platforms are built around discovery and comparison. Travel platforms enable to search across multiple third-party suppliers, so vertical search services, using APIs or data feeds, and therefore are likely to fall within scope. Users rely heavily, the users of the platform that is, on rank search results, which may surface third-party offers, sponsor placements, or promotional content. So out of the two, it is more likely that the search service will catch travel companies. But to cover everything in terms of user-to-user services, a user-to-user service is one where content generated or uploaded by one user may be encountered by another. It's probably useful to clarify at this point that it does not require a back and forth between the users. So it's not always a chat functionality. It can just be when content is uploaded by a user that is seen by another user, it could be caught. So in travel, examples would be reviews, user listings, and then if there is a more standard messaging feature, that would also be caught. In terms of why Ofcom is focused on travel, in terms of search-related results, it's all about this possibility for illegal content that I referenced earlier. So for search results, it could be fake or clone travel offers in the search results, or impersonation in sponsor placements. And then in respect of user-to-user risks, it would be fake reviews, scam listings, and fraud and scams are a priority for the OSA, so they are a focus. So now moving on to what being caught actually means for travel companies. If you're in scope, it becomes an operational compliance exercise and it's not just a legal classification. So there are core operational building blocks that you need to be thinking about and implementing within the company. So to go through them very, very quickly and not in full detail because that would take too long. Risk assessment. So that would be identifying where there is potential illegal content on the travel platform. And then specifically within the search functionality and the user functionality. So that's more of a auditing assessment process that you go through. And then once you've identified that, it is implementing proportionate controls in order to manage such content. This would be implementing measures that reflect the risk level, such as monitoring, moderation tools, and escalation pathways. This can be done through the terms and conditions, but it also needs to be functional. You can't just have it in a policy, have it in the T's and C's. These actions do need to be taken in reality. In terms of reporting and complaint mechanisms, there needs to be clear routes for users and third parties to flag illegal content with documented response processes. Governance and accountability, a defined internal responsibility for OSA compliance and decision making. And then finally, record keeping and review, which is maintaining evidence of all of the steps above, really, in terms of the risk assessment, action taken, and periodic reviews of all of the above. So, in summary of what needs to be done, if search results or reviews can be exploited for scams, you need clear reporting routes, you need rapid triage, escalation, and controls for repeated issues. Now I'm going to highlight why this is particularly important at the moment. So, to start from a simple position, the Act is now in force. Ofcom is moving from consultation into supervision. So, they provided a lot of guidance and now they're moving to the next step. As we saw with GDPR, which I'm sure you're all familiar with, the data protection legislation, regulators tend to focus first on the larger, high-profile platforms, but the expectations are still there and it will filter down across the market if we're going to take GDPR as an example. In terms of the penalties for not complying, similar to GDPR, the fines are quite hefty, specifically being up to 18 million or 10% of global turnover, whichever is higher. In terms of a recent development, which is why we're looking at this area a bit more closely, there is now a fees and notification requirement that is coming into force. The fees regime is now live, whereby travel businesses can no longer assume that Ofcom will prioritize those other industries that I referenced previously. If you're in scope, there is now an active obligation on companies that are caught by the OSA to assess and notify via the Ofcom portal in respect of the fees that need to be paid if you are caught. The first charging year for such fees is 2026 and 2027, and it'll be running from the 1st of April 2026 to the 31st of March 2027. The notification window, i.e., the company notifying Ofcom via the Ofcom portal that they need to be paying the fees, is the 11th of April 2026. So, with the speed of this year, it's coming up very, very quickly. These fees need to be paid if the company meets the threshold. The threshold is determined by 250 million worldwide revenue. That'll be your 2024 revenue, and 10 million UK referable revenue. There's a lot of detail that you go into as to what classifies as referable revenue. Broadly, it's whether or not it flows directly through the search functionality or the user-to-user functionality. In terms of when the fees need to be paid, Ofcom will issue a fee notification / invoice on receipt of the portal notification, and payment will be required in accordance with that notice. So in terms of closing off this section, even if you don't have to pay the fees, you may still be in scope and therefore need to be doing the regulatory requirements that were mentioned earlier. So I just wanted to make that clear that this distinction of the threshold is for the fees, not for the overall compliance requirement of the OSA. So that is my section done. Thank you for listening. We're obviously happy to help with any of the topics you've mentioned above. I will now pass on to Lucy, who will give an update on the travel package directives.
James, yes, on to what's going on in the EU with the Package Travel Directive. So just a history lesson reminder of where we've come from. 2019, 2021, there was a sort of general legislative review reports done on whether the Package Travel Directive was working. That coincided with Thomas Cook failing and COVID, obviously travel industry very affected. And the concerns that came out of those reviews alongside those two big major impacts were refunds of prepayments in the event of a major crisis, that there was insufficient protection of outstanding refunds and vouchers, which obviously became a huge thing during COVID, and that some of the PTD wasn't very clear in places. So fast forward to November 23, I always have to remind myself how the EU legislative process works. The Commission makes a proposal and then Parliament and Council debate it. Once they've agreed their positions, it goes back to the Commission and the three of them then finalise. So that process went through for 2 years, from November 23 to the end of last year, when the three bodies reached agreement, and then 2nd of December last year they announced and released their agreed position, which is the draft text effectively of how the Package Travel Directive is going to change. So we have that draft, and if you move on to the next slide please, Dan, I will just walk through some of the things that are coming in and those that aren't. So one of the first suggestions was that the definition of linked travel arrangements was going to be removed. That is happening, so LTAs will be no more in the EU, which will probably fall by the wayside. Not many people ever actually use them, but it's quite, I think, a good thing that they are being removed, because they were more confusing than otherwise. But it does mean that where an organiser is still inviting a customer to book additional services that won't form a package, so there's still a referral post-booking page on the confirmation page, bought your flight, car hire, where there's that referral, the customer must be told that they are not booking a package. So there's that information requirement that goes alongside the removal of LTAs. But linked to that is that what is a package is going to be expanded. There's a few different things there. There was one limb of the package definition, which was about the transfer of name, payment details, and email address to a second trader, and then a second contract being entered into within 24 hours. So it was similar to an LTA, but it wasn't. It was a package because you're transferring data. The change there is that it's just any personal data through which a traveller can be identified. If that's transferred and a booking's made within 24 hours, then you're still in the scope of a package. I think that's recognising GDPR identification, but also I think just credit card details. If you can identify a person through that, that is classed as transferring personal data, and you're possibly into a package there. The second one, which is a change to the limb, that is, you've got a package if you are offering, selling or charging at an inclusive or total price. The words adding regardless of any separate billing is coming into play. So a few, mostly across the continent than in the UK, there was a practice of having a package, but then having separate payments and separate bills, which took the package outside the scope of a package. That's now been reined in. So even if there are separate bills, you're in the scope of a package. And then the final one is that if you have not told a customer that they don't have an LTA in the first point, then you've got a package. So you've got to tell a customer that it's not a package, otherwise it is a package. So you need to start looking at your notification requirements that you send to customers if you are making suggestions post-booking. Moving on to the sort of money side and cash flow, there was a suggestion which would have been huge, I think, across the industry, that only a maximum of a 25% deposit could be taken on booking. You'll be pleased to know that that proposal has not been taken forward, and so there is no mandatory maximum deposit. You can still continue to take as much of a deposit as you want, and there is also no requirement that you can only take the balance within 4 weeks before travel. That again has gone, which will, I say, be a relief. That, so those that operate in the German and Austrian market know that that's how it works in those countries, but across the rest of Europe there aren't such restrictions, and so I think that will be a welcome relief across the industry. So then the last few points, I should say there's quite a few smaller changes across the directive itself. So these points aren't everything, but the main points I would say that we think you should know about. So unavoidable and extraordinary circumstances, which are again coming to light with everything going on in the Middle East. Do you have a UEC? If you do, that dictates your customer's right to a refund or not. The current definition of what a UEC says, it used to say that it's a situation beyond the control of a party. It's now changed to objective circumstances which are beyond the control of the party. You might think that's splitting hairs, but I think the reference to objective circumstance will obviously make it clearer that it's not anything that either party is doing themselves. It's something that's happening objectively, funnily enough. So that's the first change. The second one, again, is quite significant, that it used to be, or currently is until this comes in, that a UEC is taking place at the destination. That's now expanded so that it includes a UEC at the place of departure or the destination. So if you think back to COVID, the UK had restrictions on people flying out of the country, but in the destination it was fine. On a strict interpretation, that wasn't a UEC, and so a refund right didn't arise. That's changing, and so both place of departure and destination need to be considered. And then the final change on the UEC definition is that the definition currently says that a UEC has happened effectively or is happening. It will change so that there is a reasonable expectation of a UEC happening, which again will broaden out. Say current situation, will flights to the Middle East take place? If there's a reasonable expectation that they won't, you are into the UEC category basket and everything that comes with that. So that's UECs. Vouchers, which you will all remember well from COVID. There was always a question over how they were treated. There is no change that a customer must still be offered a cash refund. That has not gone away, but a customer can accept a voucher, as they always could. But the cash refund still is king, if you like. But vouchers are to be protected in the same way as cash now, effectively, so they will benefit from insolvency protection if a voucher has not been spent, if a travel company goes into insolvency. So that gives some clarity. But also, vouchers will have a validity period of a maximum of 12 months. And you can agree to a further 12 months with the customer if they're happy to. But if you go outside that 12 or 24 months, if it's agreed, you've got to give the cash refund then. So vouchers don't just disappear and you keep the cash, you have to give the refund. The right to redress, that currently, if you're aware, there is a right to seek redress against a supplier. So airline, hotel company, if they cancel the part of the package which you as the organizer become responsible for. There is going to be a new addition that member states must ensure that service providers give refunds to organisers within 7 days. Obviously, the idea is to help the organisers with their 14-day period obligation to refund. But it'll be interesting to see how member states ensure that service providers must give this refund within 7 days, and for flights, for example, how that sits alongside Regulation 261. So we'll need to wait and see the detail on that. And then lastly, just a couple of other, say, smaller points. If you recall, a travel service, you've got flights, accommodation, and car hire, effectively. The fourth category is the other travel service, which becomes a package on current wording if a significant proportion of the value means that it is part of the package. That significant proportion test is now solidified at being 25% of the value. That's been in case law for a little while anyway, but that's going to be now in the directive itself to give some clarity. There's a test of whether the other travel service as an essential feature is still there, so that's irrespective of the 25% value change. And then the final 2 points is you've got to give more information to your travellers, and you've got to put more in your booking conditions if it's not there already. Even though you can charge a termination fee in certain circumstances under the directive, if that's not written into your booking conditions, you're not going to be able to exercise that right to charge a termination cancellation fee. And you've got to give different information on complaints handling, for example. There's been a change to the platform that manages complaints at the EU, so there's been a change to how complaints are handled, and complaints must be handled and dealt with within 60 days from the complaint being made, and these things need to be in your terms and conditions if they're not already. And then the last bit, there's no need for a traveller to request a refund where you've got the 14 days. It's going to be an automatic right to a refund, which may or may not have happened anyway, but be aware that you don't need the customer to ask for the refund first. So what's next with this? Yesterday, apparently it was going to be voted in the European Parliament, so it was going to become law yesterday. I haven't seen an update that it's happened, but it's imminent basically. Once it's in the official journal, that's when it's officially in force, and that's expected March, April time. Member states then have 28 months after it enters into force to put it into national law. So we're looking at July, late, Q3, Q4 2028. So we've got a couple of years yet, but those changes are definitely coming down the track now. So time to start thinking about whether that's going to affect you. And of course, I should say this is EU directive, not UK. UK PTD reform is different and running alongside this, but not yet formalised. So this applies if you're selling into the EU market. That is all, and I shall hand over to Jess just to finish us off on ATOL.
Thanks, Lucy. Hi, everyone. So I will be giving a very brief overview of the changes to the ATOL advertising rules recently confirmed by the CAA, which will affect how travel businesses promote ATOL protected holidays and flights. Now, the key date to remember is the 1st of April 2026. So these changes haven't come into force yet. And this really should just serve as a good reminder to review your advertising practices and ensure that you're ready to comply. The amendments relate to ATOL Standard Term 1.3 or AST 1.3, as I refer to it, which is the term that every ATOL holder must comply with. And the changes represent a significant shift in how the advertising requirement works. So as a reminder, I've included the current wording of AST 1.3 on the slide. And ultimately, the current rule is limited to broadcast media such as television, radio, and cinema. And it's very prescriptive about what must appear in the advert. So where there is audio, the words ATOL protected must be spoken. And visually, the ATOL logo and ATOL number must be shown on the screen throughout the advert and not just briefly at the end. Now, the CAA has recognised that advertising practices have evolved significantly in recent years, with ATOL holders increasingly advertising through a variety of non-broadcast channels, including digital platforms, social media, influencer marketing, short-form video content, and broader brand campaigns rather than specific product campaigns. So as a result, the broadcast-only rule that is appearing on the screen no longer accurately reflects how travel services are marketed today. And in 2025, the CAA published a consultation proposing changes to modernise AST 1.3 and make it future-proof. And these amendments I'm discussing stem directly from that consultation. So the changes are on the slide, and the first part shows the amendments to the previous wording to illustrate the differences. And then the second is just the clean version that will be published in an updated Official Record Series 3 in due course. So in terms of the key changes, the rule expressly applies to adverts aimed at UK consumers, and it's no longer limited to broadcast media, so it will apply across all forms of advertising. So the focus is now on the content of the advert itself rather than the format or the channel. Now, as you can see, it states that the advert must contain references to ATOL protection. So the CAA will no longer be able to prescribe exactly what must be said or shown, and instead ATOL holders must include references to ATOL protection in a way that is proportionate to the format, the available space, and the style of the advert. So, for example, if an advert includes the brand's logo, then it should also be possible to include the ATOL logo. So it really does depend on the style of the advert. This is quite straightforward and self-explanatory, but the CAA has produced this helpful decision tree, which explains when AST 1.3 is triggered. So I'll just whiz through it quickly. The starting point is straightforward. Is your advert aimed at UK consumers? If the answer is no, then it won't be in scope. If the answer is yes, then the next question is, what products are you selling? If you only sell ATOL protected products and not separate travel components, then AST 1.3 will apply where you're advertising a specific ATOL product, although you may also choose to include ATOL references more broadly across your advertising. If you sell both ATOL protected products and separate travel services, then you need to look more closely at the content of the advert. So the key question becomes, are you advertising a specific ATOL protected product? And that will need to be assessed on a case-by-case basis. If you refer to a flight inclusive package or you show a package price, then AST 1.3 will apply. If instead the advert promotes general brand awareness, a destination, or a standalone product, then it's unlikely to fall within the scope of AST 1.3. Now, the guidance also recognises that there will be grey areas. So if the advert could reasonably lead a consumer to infer that a flight inclusive package is being promoted, even if no explicit reference is made to a flight inclusive package, then the CAA suggests that wording such as all flight inclusive packages are ATOL protected should be included. So just quickly, a few points on influencer marketing and how that operates with AST 1.3. So also from the 1st of April 2026, where travel brands work with affiliates and influencers, then any content promoting ATOL protected services will need to comply with the updated AST 1.3 requirements. Now, importantly, AST 1.3 will only apply to influencer content where there is a contractual relationship between the ATOL holder and the influencer, and the ATOL holder has editorial control over the content. So where those two conditions are met and the influencer makes reference to an ATOL protected product, then the content must include an appropriate reference to ATOL protection. So the general rule is where you control promotional content, you are responsible for including ATOL protection references. Where you don't control it, i.e. search results, then the rule does not apply. Now, just to summarise, this has been a canter through. So in advance of the 1st of April 2026, ATOL holders should audit current advertising content, review all advertising formats, particularly digital and social media posts, to identify where AST 1.3 may be triggered, review and update marketing templates, so ensure that brand guidelines allow for inclusion of ATOL references where required, review influencer and affiliate agreements to ensure that editorial control provisions are clear, and finally, provide training to marketing and digital teams on when AST 1.3 is triggered.
Thank you, everyone. That brings us to the end of the content. We've just had a few questions through, which I'll quickly deal with, all on the EU PTD. What date does it come in? Does it cover the UK? So say another couple of years, 2028, before it's officially in force in each member state. Oh, sorry, it's EU in force very soon, but member states have 28 months to transpose it, so it'll be 2028 before it comes into force there. It doesn't cover UK consumers, but it covers UK businesses selling into the EU. So if you do that, you need to be aware of it. Another question was, how are the UK courts likely to view the EU PTD, and will we find the principles being used in the interpretation of the PTRs? Short answer is UK courts won't have to at all. The UK PTR review, which is ongoing, has got some similarities to the PTD, so removing LTA, changing the package definition, the right to redress, albeit it's not, I don't think, a 7-day obligation being included. So there will be some similarities, but there are going to be divergences now, which we'll start to see. So no, the courts won't have to, and the CMA won't have to abide by the EU PTD changes either. And then final question on the PTD. Will the new EU PTD supersede member states' policies, or can member states still enhance it? Example, final payment collection in the DAC region. Member states can still make additions as long as they don't remove any of the rights in the package travel directive. So member states can still enhance rights. The deposit and balance payment rules that are in place in Germany and Austria are as a result of case law over there, and that won't change. The PTD won't change that. So fully expect that all of that will still stay in place. One more question on ATOL, Jess. If a travel agent produces an advert, example in a newspaper, that has both ATOL protected and non-ATOL products, is it sufficient to have a catch-all statement at the end of the advert? Example, that all flight inclusive packages are ATOL protected, or would it need to be more transparent?
Where specific ATOL products are advertised, that statement would be fine. You just need to signal that it has ATOL protection. So where there are both ATOL protected and non-ATOL protected products, I think a catch-all statement, like in the question, it says, all flight inclusive packages are ATOL protected, non-flight packages are ABT protected. I think that would be sufficient for the purposes of AST 1.3, because you just need to signal that the relevant products have the right protection.
Right, I will draw it to a close. Thank you very much. If you do have any more follow-up questions, give one of us a shout. But thank you for your time. Thanks for joining us, and we will see you all soon.